Back on the Common Sense Club of the Scott Adams Show. Our next guest is Al Carlson, House Majority Leader in North Dakota. Scheduled to join us for about 10 minutes here, but I understand, Al, you have some pressing meetings to get into in Washington, D.C., so tell me how much time you have there, my friend.
Yeah, that'd be the max I've got, because I'll be on stage here pretty quick.
You're going to be on stage? What are you doing?
Well, there's the Nuclear Energy Institute's having a big meeting down here, and I chair a National Energy Committee, and they want to talk about what role states could play in helping them expand their market. So I just kind of give them a review of what we've studied for the last year and a half in our committee.
Well, fantastic. How
First
realistic?
of all, I'm going to brag a little bit about North Dakota, Scott. That's why I start everything with a bragging session first.
Well, you should. I mean, it's a lot to brag about, and I know I sometimes bristle because we have listeners, obviously, in all throughout the heartland of the United States. But really, and obviously, if you're in Minnesota, you're benefiting when you flip on the switch from North Dakota coal. So we're all in this together. If if you go to the pump in South Dakota, you're paying more at the pump right now because we won't open up more domestic drilling like we're doing in North Dakota. So we have the key that really can fix a lot of what's wrong with this country right now, don't we?
Absolutely. I did a little calculating this morning for my bragging rights. If you take 500,000 barrels of oil a day, 365 days a year, that's 182 million barrels a year that we send into the United States domestic oil supply. That's a big deal.
Yeah, we have Steve Moore of the Wall Street Journal coming out, giving a speech to the Economic Outlook Forum of the Fargo-Moorhead West Fargo Chamber tomorrow. We're going to take him to coal country and to the oil patch so we can see things firsthand tomorrow. And, I mean, this is a big national story. Now, speaking of the group you're speaking to today, how realistic is it that North Dakota could also at some point have nuclear power generation here?
Well, and the whole focus is switching on nuclear to these smaller reactors, which are more regionalized, and we have exactly what they need. We have an abundance of water, and we have a transmission system that, with expansion, can move their products. So it may be down the future. Coal is still king for us.
Anyway, I wanted to talk to you a little bit about the decision to hire an attorney in the constitutional challenge of the Fighting Sioux law. And Mike Jacobs wrote about that this weekend in the Grand Forks Herald, saying essentially that when you convened a meeting of the legislature's operations committee to hire legal counsel to counter what you called an attack on legislative prerogative, that essentially we have the most significant constitutional confrontation of recent North Dakota history. Is that what it is?
Yeah, well, it sure is, because this is way beyond the Sioux name. The legislature is basically out of the Sioux issue. I mean, we passed the bill, we repealed the bill, the people brought it back. The Secretary of State got sued by the Attorney General, who opted to represent the Board of Higher Education. It's his responsibility to represent us or who we recommend. We tried to work through the Secretary of State, Scott, to say, we'd like to recommend some constitutional attorneys because the brief is very broad and deals with our authority to basically deal with anything except other than money in higher education. So, and he said, no, you give me some names, but we'll pick our own guy. So we opted that we didn't really have an option. We had to join in on this because the brief is much broader than the Sioux name. People get all excited and they let it drop. This isn't about the Sioux name. This is about the role of the legislature in relation to the Board of Higher Education.
And, given the Board of Higher Education's reaction to the signature gathering to put this question on the ballot, a lot of what you proposed in the last legislative session to give more power to the people in governing the institutions that they earn has really almost leapfrogged the Fighting Sioux issue, hasn't it?
Oh, yeah, it's become a big issue now, and we need to take a good hard look. The citizens in North Dakota, there's a group of citizens preparing an initiated measure. Sean Johnson and a group of people are looking at one to create a Department of Higher Education. I had a bill in last session to put it on the Constitution to create a Department of Education, which would have K-12 and higher ed, and many people, it passed the House, failed in the Senate because they thought it was too broad. His issue will deal strictly with the Department of Higher Education and electing that person. So we'll see where that goes. But, Scott, This is an issue that if the brief hadn't been so broad, there's a lot of things the Supreme Court could do. They could throw the whole works out. They could have a narrow decision. But no matter what it is, next time someone like a Max Schneider, who was against us hiring an attorney who sponsored a bill to limit tuition, wouldn't be able to do that because he was micromanaging or getting in the way of running higher education. So it's funny, the people that oppose this getting attorney are the people who were trying to pass bills to deal with that. So kind of interesting how it goes. But the legislative branch needed to protect itself or to have an opinion and a council at the table to say, the Constitution clearly says that the Board of Higher Education is not the fourth branch of government. It is constitutionally recognized, subject to constitutional and legislative limitations, which we feel are the laws we pass. So we'll see how it goes. This is a big deal.
Now, Wayne Stenjum has made it quite clear that the constitutional advantage, according to his reading of the law, is at the Board of Higher Education level. Do you think he's right in the review of as it pertains to the X's and O's of the law that they have a leg up here?
Well, I don't agree with him. Obviously, we've never agreed with him. We had the discussion before the bill was ever passed. We think we have the authority to do that, and we think the Constitution gives us that authority. He disagrees. He's come out very openly and says that he believes we overstepped our bounds, and he has opted to represent them. He constitutionally could have picked us or them. He opted to represent them, and a lot of this goes back, Scott, to the agreement that was signed and making sure that agreement stays in force, and that he was right on that issue. So we're not here to pick a fight with him. We're here to clear the air, find out which direction the Supreme Court views this, and there's a lot of different situations that they could come out with. But also what it does is it denies the people the right to vote on what they wanted to vote on. And that's probably the sad part of this, is that this puts an initiated measure on the shelf until this is resolved.
Yeah, to give me the timeline, when do you sense this will be resolved?
Well, they have to have it resolved by April 12th because that's when they have to have the final decision on what will be printed on the primary ballot. So this is a very, very short window for anybody to get a brief ready and to defend this case and build their case. So we'll see. Our guys are going to work. We hired an attorney. It doesn't cost them. There was a number. They said, "Well, how are you going to pay for this?" And we couldn't give them an exact cost. And Al Knudsen from our council said, there's $250,000 in a professional services line. So immediately somebody picks up on the fact that that's what it's going to cost. Absolutely not. I don't know if it's $5,000 or $8,000, but it's going to cost in a 2-week time frame. There's only so many billable hours. There's only so much money that's going to be spent on this, and it's going to be well spent as to how we view the governance of higher education, how the Supreme Court views it, how the Attorney General views it, and after that, how the citizens view it.
There was always a plan by supporters of the Fighting Sioux name and amongst the Native American community to ask the constitutional question later anyway. Regardless of the outcome over the repeal of the repeal and whether citizens will have a vote on that, there would be, ultimately, if you change the Constitution and citizens agree, that fixes everything from their perspective, doesn't it, later?
Well, it probably does, but this issue is, I'm really tired of all the rhetoric coming out of the university that they're going to lose all their conference affiliation. Show me the beans. Let's call every college president and every AD director in the Big Sky and ask them, is there a motion on the table to kick us out? Let's find it out instead of just running these scare tactics.
Well, yeah, not to mention, everybody assumes the NCAA will not change their position. I happen to think the citizens voting might give the NCAA a big incentive to change their position. They don't want this to become a national issue. So by stopping the citizens, you have the difficulty of the NCAA remaining entrenched. Let them vote, and they may change their mind. Al, go do North Dakota proud as usual. Thanks for the time today. We appreciate it. More after this, folks. Don't go away.